A very good evening to all of you who have joined us. And today we are here for a very special talk. Amidst the recent events as they have unfolded with respect to judiciary and its interaction with other organs and subjects of the state, be it a recent letter written to the Chief Justice of India or the contempt proceedings or the judicial overreach on one side, and some personal remarks, baseless allegations, ideological comments, which are there to ensure some kind of forum shopping. So it becomes quite important to have a discussion on freedom of expression and the courts in order to find a very fine line of balance between the two. And today we are fortunate to have amongst us Dr. Venkat Iyer, who is a barrister and a legal academic based in the United Kingdom. He has practiced in India as an advocate between the year 1981 and 1990, and he is also a trained mediator. Dr. Iyer has been a press fellow at Cambridge University, England, and has held illustrious numerous appointments, including the Law Commissioner for Northern Ireland, and he has also consulted as he specializes in media and constitutional law. He has advised and has been a consultant to many governments, including the royal government of Bhutan, where he was invited to advise on and draft the media laws for the kingdom. And he has also carried on several similar assignments in several other states, including Burma and Kenya. He has a very distinguished profile, having lectured in more than 30 countries. And he has also been engaged in designing and delivering capacity building programs for judges and magistrates in various jurisdictions. So we are privileged to have Sir amongst us. And with him, we have our very own, who is a regular interactor of ours, Mr. Siddharth Sijoria. He's a practicing advocate in the Supreme Court and the Supreme Court of India and several other high courts. He has completed his master's in law from Central European University, and he has also been associated to the chambers of legendary senior advocate Mr. T.R. Arjuna. So he will be in conversation, and Dr. Venkat Iyer would be answering the questions and interacting, throwing some light upon this topic. I invite both of our distinguished guests to start.
Thank you, Nitish. So, sir, as Nitish has already pointed out, these days we are witnessing that a lot of discussion has been happening around the judiciary, which never used to happen before. Maybe because of the media and the social media where people can put anything. So, sir, my first question to you is that should one person be allowed to criticize the judiciary and the judgments of the court? And yes, and if yes, sir, are both type of criticism allowed within the scheme of Indian Constitution, especially as a part of freedom of expression?
Oh, and can I, before I answer your question, thank you both. Also say how pleased I am to be on this webinar. I must confess, I did not know much about Niti Manthan until Nitish got in touch with me just the other day. But I'm glad that we've been able to meet today, and I'm hoping that we'll have a fruitful session. Now, going back to your question, Siddharth, the answer, of course, is yes. The judiciary, like other organs of the state, is not immune to criticism, both for its own good and for the good of society. As Lord Atkin famously said, justice is not a cloistered virtue. And in the UK, it's not uncommon to read very trenchant criticisms of the judiciary in the media, and yet no action is taken. The correct legal position is to be found, I would say, in among other judgments, the decisions of the House of Lords, particularly in the case of ex parte Blackburn, which was a 1968 case. And if you see the observations of Lord Denning and also Lord Salmon, then you will realize what approach the court will be taking in that regard. Now, about court judgments, again, there is no justification on principle or on practical grounds for criticism to be banned. When a judgment is delivered, it enters the public domain and it should be open to scrutiny and analysis by everyone. That is definitely the case in mature societies, although one should exercise some caution when there is a possibility of an appeal in sensitive cases. Now, that having been said, I would add that for reasons of ethics and good taste, even the strongest criticism should ideally be made in polite and temperate language. Those satire and humor are effective as well. For anybody who's interested and who enjoys humorous writing, I would recommend an article from a British journalist called Bernard Levin, who was extremely good at critiquing the pomposity of judges.
Uh, Thank you, sir, for this response, sir, because my next question is something which is connected to this question, because we need to understand where is the lining that we need to draw to understand what is contempt and what is free speech. Now, under the Court of Contempt Act in India, a contempt of a court is committed the moment or when an individual scandalizes the court or tends to scandalize the court or obstruct the administration of justice. Now, sir, to a layman, how would you explain to a layman that his under what circumstances his conduct would be construed to mean that he is obstructing the administration of justice?
Right. I have to admit that the wording of the Contempt of Court Act in India is quite intimidating, especially if you're not trained in the law. But despite its breadth, there is, in my view, a lot of scope for acceptable criticism of courts and their judgments. Specifically in relation to your question about interference with the administration of justice, one obvious example will be where a person disrupts proceedings in a court of law by reporting abuse from the public gallery um, at a witness or at a lawyer or at the judge. I've also come across news reports from India about physical interference in the form of, let's say, a disgruntled litigant throwing a piece of footwear at a magistrate or a judge. In modern times, I would suggest that persistent disregard of a requirement to keep your mobile phone off or on silent can also amount to interference with the administration of justice. These are called contempt in the face of the court. Although any action taken against such behavior will have to be preceded by a warning. An extreme example of interference would be the kind of behavior that was witnessed in the Madras High Court in 2009 when lawyers ran amok inside court premises, which resulted actually in a judge getting seriously injured and a lot of other people affected. In the UK, we have in the distant past had cases of a person throwing a dead rat at a court clerk, distributing leaflets in the public gallery, wearing offensive clothing, even a person appearing naked in court. So, if you want to talk about interference of a different kind, then you can also think about threats issued by anyone in a speech or a letter or through an article against a judge. Some years ago, I came across an odd example of alleged interference. It arose from, I understand, a railway official denying a judge from the Allahabad High Court a berth on a sleeper train, and the judge immediately charged the official with contempt of court. This incident, if it is true, was as outrageous as it was absurd. The judge in question, incidentally, gained further notoriety after being embroiled in a corruption case many years later.
Thank you, sir. So, like you mentioned that because of like a judge making a railway official holding him guilty of contempt of court when he was not even obstructing anything in the course of justice. Now, this brings me to my next question, which regards to the definition of contempt under the Contempt of Court Act, because under the Court of Contempt Act, it defines two types of contempt. First is the civil contempt, and next is the criminal contempt. Now, for a civil contempt, basically in the court defines civil contempt to means any disobedience to the court orders, and criminal contempt is defined so broadly that any criticism against the judiciary can be construed to be a criminal contempt, sir. Now, sir, essentially and interestingly, the offense of criminal contempt does not require intent as a necessary ingredient. And as we all know that under the criminal jurisprudence, intent is a sine qua non for any offense, which means that it is necessary that you have it. Now, in some jurisdictions, intent is necessary for holding a person criminally liable for contempt of court, and in some other countries like in UK, intent is not required for holding a person guilty of contempt of court. Now, sir, do you think that not requiring intent as a necessary ingredient for holding a person guilty chills the free speech and right of a individual to criticize the judiciary, because he may be under threat that his conduct can be construed to be violating the code? Also, I want your opinion on, do you consider that offense of criminal contempt be retained or it should be abolished?
Right. I'm not sure that the absence of a requirement of intent necessarily introduces a chilling effect on free speech, because it depends on how the contempt power is actually used. In many situations, it'll be clear that the accused person would know the consequences of his action. For example, that shouting abuse in court, even if it is not intended to disrupt proceedings, but say to give vent to frustration at something, would still lead to disruption, and therefore to also interference with the administration of justice, which is part of the definition of criminal contempt. On the larger question of whether the offense of criminal contempt should be retained, my answer is that, all things considered, I would be against abolition, mainly because it does serve a useful purpose in certain situations which are still quite possible or even likely, especially in countries like India, where people do get excited and worked up quite easily. Um, I can refer you to the case with which you're all familiar, which is the case of the former Justice Kannan, who did, as you know, create a big kerfuffle not so long ago. But I do think that the power should be used sparingly. Sadly, that's not been happening, and it should be a matter of concern. There are just too many cases of judges acting in a gung ho fashion. And what is worse, sometimes they use criminal contempt powers simply to bolster, massage their egos. To give you an example, I was appalled to read about a case some 5 years ago when a judge of the Kerala High Court, a man called P.D. Rajan, who mercifully is now retired, apparently punished two police constables for contempt simply because they had addressed him casually but respectfully as elder brother outside court and at a temple festival which the judge had been attending in his personal capacity in civilian clothes. The constables were asked to present themselves in the judge's court shortly thereafter, and copies of the police manual were handed over to them, and they were asked to write down or copy certain parts of that manual by hand as punishment while standing in court all day. Now, this is the kind of behavior which brings a bad name to the entire judiciary, and which also makes ordinary people think that the law is defective when it is not.
Right, sir. Right, because I think this is, you would find that these contempt stories are never reaching the mainstream media, because I think on every day some judge in Jharkhand or some other court would be initiating contempt proceedings, and we don't have a record of everything. Like, I'm so happy that you can share these stories, because I was never aware of these stories, sir. Now, sir, this is where you talk about that judges take an umbrage, or to massage their egos, they introduce or give any kind of punishment that basically suits them. So this brings to me to the next question to you, which is about that under the Indian legal system, the power to issue contempt proceeding against an individual exists even in the constitution, as well as the contempt of court act, sir. Now, sir, in many judgments, the Supreme Court has observed that since Supreme Court and the High Court are the court of records, they have the power to issue contempt independently of the parliamentary statute, which is the Court of Contempt Act, sir. And sir, because of this, they also say, and they also have observed that they are not bound by the statute, and most importantly, in cases regarding the punishment, the court say, and they have observed that they can give any punishment to a contemner based on the system, that it should be fair. Now, sir, do you think that such exercise of power renders the position of the law unclear and gives arbitrary power to the court? Because in some cases, the court have actually suspended the right of a lawyer to practice law before the courts, and such power is, or such punishment is unfounded in the statute. So, sir, what are your views on on this unclear position of law, particularly in relation to the punishment that the court can give?
Well, I do think that the position is unsatisfactory. But I think that until the Supreme Court of India, through a large bench, brings about a radical shift in the position, the argument about inherent power, which is what it is all about, will continue to hold the field. I'm personally less worried about this than about the manner in which contempt power is used by the judges. A lot of lip service has been paid in various judgments about how sparingly the power should be used, and despite all that, the practice on the ground seems to be very different. The power should certainly not be used irresponsibly or with vindictiveness. About the suspension of lawyers or the removal of senior designation, as happened in a case in Gujarat just a few weeks ago, I can see limited circumstances when resort to such punishments may be justified. But a better way of dealing with such cases would be through normal disciplinary procedures rather than through the use of inherent powers of the court. If necessary, the disciplinary procedures should be beefed up, but only after ensuring that the toughened procedures comply with due process of law. The sad reality in India is that the regulatory bodies leave much to be desired. I'm talking about the bar councils, and sometimes they are worse than useless.
Yes, sir. Yes, sir. So, sir, now, sir, the next question that I want to ask you is concerning the age-old principle of no one should be allowed to be a judge in its own case, sir. Now, sir, we see that in suo motu proceedings, a court on its own decides to initiate a criminal proceeding, or a contempt proceeding. Where, sir, do you think that as a practice, especially as a practice, the court should take opinion from the AG, the Advocate General or the Attorney General before initiating a contempt proceeding? Because otherwise, like you say, like you said before, that sometimes it appears that the judge is trying to massage his ego, or judge is just trying to be vindictive. In such situation, a court or a judge can misuse these proceedings, and therefore it should be required that an opinion is sought before initiating contempt, just to avoid any kind of criticism which may be well founded, and which may allow the judges to misuse the system.
Absolutely. And that's an important and valuable safeguard which cannot be brushed aside lightly. Not many people may know this, but granting or denying permissions to launch contempt proceedings is one of the public interest functions of the Attorney General. and this has to be performed independently of the government. At least that's so in jurisdictions like England, and attorneys general in those jurisdictions take that function very seriously. In cases where a court plans to take suo motu action for contempt, it will at least be good practice to seek the views of the AG and to take them into account, because it will mean that a professional who is not involved in the controversy directly will have considered the matter independently and applied his mind to the pros and cons of the case. I would venture to suggest that seeking the advice of the AG is good for the court also, because if it is subsequently criticized, then it can indicate that it did not act impulsively.
Right, sir. I think that is a valuable suggestion that even that the court should consider, because I think it would do away with the criticism that judge is being a judge in its own cause, which I think can be problemsome, because we have recently seen when the Prashant Bhushan was convicted of the offense of criminal contempt, there was a lot of debate whether the court should have initiated the contempt on its own, or it should have considered the opinion of the AG before initiating the contempt proceedings. And so now I would like to ask you regarding the case where Prashant Bhushan was convicted for the offense of criminal contempt, sir. Now, sir, in his case, he wrote two tweets on Twitter, and those two were taken into account by the courts to suggest that these two tweets constitute constitute the violation of the judiciary in its entirety, as well as it lowers the reputation of the judiciary in the public eye and causes the obstruction of administration of justice. Now, sir, what is the parameters that the court take into account to calculate the harm to the institution? Because there's nothing, there was only tweets or retweets that were shared on the internet, or there was nothing that people came out on the street against the judiciary or expressing their displeasure with the functioning of the judiciary. So, under what are the parameters, or what to calculate the harm to the institution? So, what are those parameters? Because I think in US the court takes into consideration the principle of clear and present danger, where the court treats imminent danger to the administration of justice to be contempt of court, not an imminent threat. So, sir, what are ideally the consideration that the court take into consideration while initiating contempt, sir?
Well, specifically in relation to your question about what do you think the Supreme Court, what criteria the Supreme Court uses in such cases, I wish I knew the answer to that question, and quite frankly, I don't. Sadly, recent years have seen such a precipitous fall in the standards of judgments and legal reasoning from the Indian courts that it's impossible to work out any pattern or any approach in such matters. I also have to say with great regret that the understanding of some of the judges about how concepts like contempt of court or defamation are meant to operate appears to be becoming uh, worryingly weak. Let me give you an example. About a week or so before taking up his office, the current Chief Justice of India was reported in the media to have said, and he gave I think, a televised interview to NDTV, and he said something like, criticizing the judge and not judgment is defamation. I think I'm using his exact words. And mind you, he said that without any qualification. Now, leaving aside the grammatical imperfections of that sentence, it is truly astounding that someone who was going to occupy the highest judicial office in the land could be so uninformed about a simple but fundamental principle of law. And he is, of course, not alone, which is very sad. Now, you mentioned something else a little earlier about bringing down the reputation of the courts. It is not the function of contempt law to address that problem. That problem will have to be addressed through the use of the law of defamation by individual judges. The purpose of contempt law is something very different. It is to preserve the authority of the courts, and the majesty of the law.
Right, sir. Because when I was reading the contempt court, the court has actually gone on to define the tweets on the basis of the affidavit that was given by Mr. Prashant Bhushan when because the court discusses in its judgment that what Prashant Bhushan was implying through his tweets was that basically judiciary has subjected itself to the executive, and therefore the judiciary is not performing a role which is to keep a check on the executive authority. So basically this is how the court interpreted his two tweets, which I thought, which is going down to read what was published and what was submitted to the courts in its affidavit, which were not reading of the tweet as such, but implying meaning of the tweet through the affidavit, which was very. So this was the reason why the court found him to be guilty of obstructing the administration of justice. Now, sir, this is with regard to the contempt of court when we are looking at the statute itself and how Indian Supreme Court have dealt with the issue. So now we are witnessing another significant or insignificant uh, thing in the media these days, which is the media is running media trials. Now you can see that today every case before it goes to the court is widely discussed in the media, and what media is basically running is a media trial. Now, before even the court can initiate a trial of the individual concerned, the media already influences the public opinion, and the person concerned is declared to be guilty even before the process of law can begin. Now, so certain publication which of such nature or certain broadcasting or debates on the media about the conduct of the case or about the case itself, which prejudices the mind of the public, is considered to be contempt in many jurisdictions, including Europe and in African jurisdiction. So, do you think that even in India, we need to either completely ban discussion about a case before it reaches the trial, or there should be a balance that should be struck between the freedom of speech and expression of media and the fair trial of an accused? Because on the total, if you discuss something which tend to influence the masses, which it basically violates it biases the person concerned, and it influences the media, and it influences the public at large. And the person, like recently we saw with the Sushant case, that there was so much of discussion in the media where the accused was declared to be guilty even before the trial could begin. So, sir, do you think that we need to balance these issues and basically not allow the court to be biased with the opinion of the media? And also, sir, do you think that the media reports do bias or do bias judges?
Well, I would certainly not advocate a complete ban on media discussion of pending cases. That would not only be draconian, but also in the long run unhealthy for democracy. Yes, there have been several cases in the UK where newspapers, in particular, have been punished for interfering with ongoing trials. But you must remember that there's one crucial difference between the UK and India, and it is that in India, there are no jury trials. That makes a lot of difference because judges are, by their training, conditioned or meant to be conditioned to disregard what they see, read, or hear in the mass media, which is not to say that there should not be restrictions on the media reporting of ongoing cases. There should be, for example, media interviews with witnesses who are yet to testify in criminal trials. That should be a particular focus of legal restrictions. But a more effective solution, which may or may not work in India, is inculcating a greater sense of ethics, by which I mean self restraint, in media organizations. I'm appalled at the horrendously unethical behavior of journalists in India, especially on television, but also in newspapers. They deserve as much criticism as does the judiciary. There's no doubt that striking a balance between freedom of the press, which don't forget includes the right of ordinary people to information, and the right to a fair trial, is difficult at the best of times. But the situation, I fear, seems to be getting out of control in India.
Yes, sir. I hope so, the government, because I think recently the Bombay High Court is considering something similar with regard to some news channels in India, where the courts, with regard to the TRP issues, the Bombay High Court is dealing with this issue, and I hope the court comes out with some guidelines that can later be adopted as in statutes. Now, sir, like there was a book that I was reading recently by Yuval Harari where he says that in the age of over information, clarity is power. Now, sir, it is a fact that we are living in an age of information overload. Anyone can say anything on the internet, and people often say a lot of things about judges or the judiciary. Do you think that the guidelines should be introduced to regulate speech on the internet concerning the judiciary, keeping in mind that judges cannot use public or social media to put forth their opinions? Because recently we saw that an Andhra Pradesh chief minister wrote a 8-page long letter imputing allegations of corruption on a sitting Supreme Court justice, and this letter was widely circulated in the media, and people are discussing about whether the person concerned or the judge concerned is guilty or not, whether there should be an inquiry against him or not. So, sir, do you think that there should be some regulation of discussion about judicial conduct in the media?
Well, um, you started your question by talking about social media.
Yes,
Um,
sir.
and of course, what happened with the Chief Minister of Andhra Pradesh was not criticism of a judge in the social media. It was a letter that he sent to the Chief Justice. So keep that in mind. And generally speaking, of course, there are also technical issues when it comes to regulation of social media or regulation of the internet more generally. Now, I'm generally against censorship of any kind. Yes, there are risks to unbridled free speech, but on the other suffer those risks. Though it would be good if they were avoided, then muzzle the free flow of ideas and opinions. For very good reason, India has adopted a system like the UK under which prior restraint, which sometimes people wrongly call pre censorship, applies only to motion pictures and maybe dramatic performances, if my memory serves me. For all other media, the rule is that if you break a law, you pay the price afterwards in terms of civil sanctions or punishment. I wouldn't want to upset that system, however imperfect it may be. But there is something which cries out for massive reform in India, and that is self regulation. There is really no culture of ethical behavior on the part of the Indian media, and that is deeply worrying. To change that will take a very long time, at least a couple of generations, I would guess, but a start needs to be made somewhere. With some reluctance, I would be willing to consider a temporary regime of coercive measures under which particularly egregious behavior of the media would be subject to punishments. But very careful thought will have to be given to the shape and the details of any such regime.
Yes, sir. I think like it, what you just said about self-regulation, sir, it reminded me of Justice Chalmeshwar's verdict where he quoted Macaulay and reform that we may preserve. And so I think I think you rightly mentioned about some coercive measures that can be introduced, but again, with the kind of proportionality law we are developing each day, I hope we are able to come out with something which is very least restrictive and restrictive and does tend to achieve its aims. Now, I think, sir, these were the few questions that I have prepared for you, and I think I would like to invite Nitish and ask him to give his comments and also to ask open the floor for questions if there are any.
Thank you. In fact, Siddharthji asked a wide range of questions covering almost the spectra on which the issue deals with. But there was one question, although it was covered partially, but I would like to ask very directly, as Justice H.R. Khanna also said that the judges we are without sans purse and sans power, and if we are not even in a position to speak, because then there is an allegation that you are being a judge in your own cause. So when can we express as judges? Because press conference is also condemned, and it's what so on which path, or by how, which means can we just vent out what is being told against us, or what our emotions. So what would be that stance? Because we need to have a balance between the judicial expression as well as the expression of the subjects or other organs of the state.
It's a very good question. So I'll probably have to give you two or three points by way of reply. The first thing I would say is, even before you get into a controversy, if you're a judge, you need to consider the consequences of what you say and how you behave. Because when you become a judge, you do adopt certain disciplines which a lawyer or anyone else would not be subject to. So you have to keep that in mind. Secondly, the biggest medium through which a judge expresses himself or herself are his or her judgments. So if a judge were to be very careful and very clear in their judgments, then that is half the battle won. Part of the reasons why people criticize judges, and I'm careful to say only part of the reason, is that judgments are not often very clear. They can be confusing, they can be contradictory. There are so many problems, and it is becoming a huge issue in India. As an outsider, when I read Indian judgments, a lot of the time I'm not even able to make sense of what the judge is trying to say, let alone discern any judicial reasoning. So, as long as a judge is quite clear, then he would probably not invite as much opprobrium as he tends to do. But there's a practical way in which unfair criticisms can be dealt with, which is the way that a lot of judiciaries nowadays are doing, and that is for the press office in the court to issue statements. Again, these statements will have to be very measured because a judge never gets into a slanging match with his critics. That is no way to do business in the judiciary. But it is possible, for example, if somebody, let's say a journalist, was to write something completely wrong and show a tremendous amount of ignorance about a judgment, and then unfairly criticize the judge, I think it's entirely reasonable for the press office to clarify the position. Just clarify, not get into a slanging match. So I think there are different ways in which all this can be handled. Of course, nowadays it's not uncommon for judges to address public meetings or attend seminars and speak at seminars. And some judges take the opportunity to, if you like, hit back on their critics through these platforms, through these speeches, etc. I'm not sure if it's a good thing, but you can see that there is a wide range of measures that may be available to a judge.
Thank you, sir. So coming with the second question, we dealt with a case where the judge is being criticized by media or by some individual on social media. The second scenario was when a judge is criticized by some organ of the state, another organ, let's say executive, when there was one example, or by the advocates who are appearing before them. But there is another angle to it, that is the judges being criticized by another judge, maybe serving judge both on the bench, and like we saw in 1980s, late 70s and 80s, there were two prominent judges, one on number one and number two. So at this situation, what do you think and what picture it portrays? Because even in the recent past, we saw many such things going on, where the freedom of expression has taken an altogether different dimension, where no one outside judiciary is involved, but within judiciary there's a tussle in expression. So what are your comments upon it?
Well, that's not a problem that is easy to resolve because it is so connected with the personality of judges. Um, Now, again, I have to be very careful in how I put this, but if you compare the quality of judges who sat on the bench, particularly higher judiciary in India in the 50s and 60s, even 70s, you'll notice that they were of a completely different kind if you look at the record of subsequent judges. So that is important. If you are self confident, if you are genuinely erudite, if you're able to express yourself well, then quite frankly, none of these things should happen. A lot of these problems is the result of insecure personalities. And of course, don't forget, there's also unbridled ambition, which drives some of this poison. So why does number two want to put down number one or vice versa? It is because there is a burning desire on the part of one of them to trip the other. So these are kind of things which are very personal. They are not institutional. I suppose the institutional answer might be for there to be good leadership at the top. So if you had a very good Chief Justice, then he or she could actually bring about a lot of change for the better in such circumstances, or actually to prevent such circumstances. In the UK, until about the late 1990s, we had the office of the Lord Chancellor. Now, the Lord Chancellor was unique in that he belonged to all three branches of government: the executive, the legislature, and the judiciary. So he was a sort of bridge between the three organs of state. And he was able, therefore, without too much fuss, without too much noise, to resolve any disputes that may have arisen internally. So you need mechanisms of that sort. I'm not suggesting that we need to have such a figure in India because I suspect it's not going to work at all. But what I'm trying to say is that everything depends on the particular climate which prevails in the particular country.
You just mentioned about just a difference between the judges who sat on the bench in 1950s or 60s in the initial phase of the constitution, initial phase of the newly independent India, and now. So in the morning itself, in my comparative public law class, we were discussing something on these lines, and there was one observation that initial judges were all English taught. They had their particular mindset, being trained in colonial institutes or speaking the imperial language. Whereas from 70s, mid 70s or 80s onwards, we see more Indian taught judges. So one reason that the people are, so there are two parts to this question. One is that since people are making comments upon judges, maybe it is because that these judges are speaking their language. The people are able to connect to these judges, and that is why they are able to respond to these judges. Whereas the initially taught judges, the people used to consider them as carrying on the English legacy. And since people were not, the commoners were not that interactive or vocal with respect to the English, so they were not able to interact with those judges and communicate, maybe in form of a critique or something. But in this situation, they are able to from 80s onwards. And second question is that you mentioned in your talk that the expression of Indian judges is not very clear, as you feel that sometimes it's very vague and you are not able to understand as to what it. How do you analyze the expression of judges as to do you think exposure is less? Because now I think from 90s onwards, in the mid phase could be that they were completely isolated, aloof from the world thing, but from mid 80s 90s, these are the judges who have the exposure of the West. They have altogether a complete exposure, and then they are speaking. So first is people interacting with judges as judges are talking their language, and second, the expression of the judges.
Okay, there's a lot there. I'll try to be as brief as I can, but I'll have to give you a slightly lengthy answer. So, taking the first question first, and if I forget the details of your second question, I may have to ask you to remind me, but I'll try to remember. Okay. Again, from what you were mentioning earlier, I can detect two possibilities. One is the, if you like, the English training or the English background of some of the judges of the 50s and 60s. True, and you know, I generally speaking would not want to make any observation on whether one is superior or the other. But I will say this: what you said is true only up to a point, and I can very easily uh, by example tell you that that factor is not as potent as you might think it is. So, the examples I would give is when I used to practice in India, and I was largely practicing the Bombay High Court. We had, I can immediately give you two examples of judges who were not at all trained in the English system. They were educated completely indigenously. Justice M.L. Pense and Justice V.D. Tulsapurkar. Now, Tulsapurkar, as you know, went on to the Supreme Court of India. Justice Pense was denied that opportunity. Now, we don't want to go into that debate or dispute. But these two judges were not only respected, but they also were so effective in communicating what they wanted to say. So I don't think you need to have an English education to be able to communicate effectively or to be able to behave as a judge should behave. So I would be a little hesitant to even go down that road. But there's a second part to what you said, which is communication with the public. Quite frankly, I would start by saying it is no job of the judge to communicate with the public except through his judgments. A judge cannot have a dialogue with the public. That is not part of the judicial function. In fact, I would be quite appalled if it was suggested that part of the job description for a judge is that he should be able to carry on effective communication, effective two-way communication with the public. Definitely not. Quite frankly, he should not even be expected to carry on a two-way communication with um, the bar, except obviously in court and in under certain very controlled circumstances. So no, but there is a interesting aspect to what you said, and that is, are these judges able to communicate clearly to the public through their judgments? And my answer is no. And actually, that brings me straight into your second question, which is again along the same lines, and that is, you asked what is it that makes it difficult for anyone to understand what judges are saying now, or to make out the reasoning or the ratio of judgments. And I would say, first of all, clarity. And my guru was the late Nani Palkhiwala, and he often used to say, um, clarity of thinking is as important as clarity of language. And quite frankly, clarity of thinking precedes clarity of expression. So unless you think clearly, then you won't be able to express yourself well. And I'm sorry to say that the impression I get reading many of the judgments, and again, I have to qualify what I'm saying by saying that there are exceptions. So don't think I'm painting a picture that is so black and it's irredeemable. Far from it. There are some good judgments I've read, But generally speaking, the quality of writing has gone down tremendously. And again, I should not be mistaken as suggesting that it is the poor quality of English that is the problem, because it is perfectly possible for a person to communicate very effectively in any other language. Now, in India, for example, in Hindi, and I've heard people, not from the bench, because obviously English is the predominant language, at least in the higher courts, but elsewhere, some judges speak very good Hindi. When I say good, I don't mean flowery, I mean very communicative Hindi. So it is possible. If you think right, you should be able to express yourself well. And of course, the important thing is simplicity. It is very easy to communicate well if you write what you're intending to say clearly. Clarity is sadly lacking in a lot of judgments. And I would say clarity of expression clearly is a reflection of a lack of clarity of thought.
Thank you, sir. This takes me to my last question. And after that, we have one question from our viewer, and we'll take that. Now, you just at the end of this answer, you talked about clarity and simplicity. There is one recent writ petition being filed in the Apex Court. It says that you should not be using the jargons, or you should not be using the maxims. Use very simple language in order to connect with people. So this takes me to the question of expression, not of judges, not of people against the judges or for the judges, but the expression of law which is working in the courts, be it be of lawyers appearing before the court or the judges speaking on behalf of the bench. So, do you think there is a time to change the expression in order to inject a sense of simplicity in the language of justice delivery system, so that although judges are meant to interact with people only through his judgments, but at least these judgments should be readable by people. We see recently what Kerala High Court said. So there are comments in media where they said so and so person has confessed. Now that confession is before a police officer, which is not admissible under Evidence Act Section 25. But because the expression of the law is so vague that people are not able to understand. Leave aside common people, but even the media people are not able to understand. So, do you think it is the time to change the expression? Because the colonial language was there, and it was deliberately induced to create a sort of a difference between the commoners and the people who are speaking on behalf of law. But do you think now, when it's world is getting democratic, so we need to add some simplicity in the court's language, or the language of the law?
Well, there are a couple of things I can say in that regard. Um, Now, you referred to the petition that was filed in the Supreme Court on grounds of the law being or the language being very complex, and I think the thrust of that petition was that there should be greater use of plain English. And in principle, everybody would agree with that sentiment. But how do you bring it about? It is very difficult to enforce these things through law. You cannot have a diktat, a sort of a executive fiat which says we compel you to speak in plain English. Now, to some extent, actually, this was tried in England about 20 years ago when the Lord Wolfe reforms took place, and many Latin phrases were banished from use in the courts. And for example, a simple word like plaintiff cannot be used anymore in the English courts. You have to use the word claimant. Now, I don't know if that has made any difference at all to the quality of justice. Look, you can have reforms, and language is an evolving process, and it can be done over a period of time. But to do these things in the way that is sometimes suggested appears more cosmetic than intended to be genuinely effective. But there is a problem of expression more generally, And of course, an example which can be given in the context of India is, you know, the judge who was quite popular, Justice Krishna Iyer. No relation of mine, I have to say. Now, um, he is a person who was much loved by a lot of people, but uh, he had a terrible habit of using not just long or difficult words, but words which were so artificial and so um, strange that it didn't make any sense in many of the sentences he used. And yet, um, a lot of people clap when he delivered these sentences, they're little realizing that what we need is clarity, not the use of big words. So I have some very strong views in that regard. I think it's possible once you begin to think clearly, then also to express yourself clearly. And of course, expression differs from context to context. There are certain occasions when you have to be formal, you have to use very formal expressions. Now, going back to the point you made about the colonial influence, I completely take the point. In fact, it was quite a difficult thing for me when I had to retrain as a barrister in England after having served as an advocate in India. I had to completely learn everything afresh. And today, when I read some of the pleadings in the Indian courts, I'm astounded by the flowery language, completely needless. In fact, if I were to draft a plaint in any proceeding in India, then I think the local lawyers would probably be aghast because I would probably draft a plaint which is 5 pages long, whereas the same plaint in India would take at least 50. So there are issues like that. I mean, it is possible to simplify, but there's no silver bullet which says you pass an ordinance or a practice direction which says from tomorrow you're going to use the following words rather than some other words. I don't think that's how it's going to work. It's also a process of education which starts at a much earlier level. You know, school, law school, and then you should have a good law training program, all of which will contribute to the process of speaking and writing clearly.
Very true, sir. Very true. In fact, a very simple illustration addressing the bench as lordship or ladyship. So this starts from the very first mooting class in which a student of law enters. So they are compulsorily taught that you have to address the bench like this. And once training is accordingly, when even Supreme Court has been saying, many judges have been saying, please don't address as lordship or your honor, but this trend continues, and I never saw any advocate or very rarely addressing the judge as sir, simply as sir, and not addressing as lordship or your honor. So maybe yes, not with the commandment of the bench, but through the self discipline or inducing a self sense of direction as to what to take. So
But
we
you
have.
know, you haven't taken into account the self-importance of some of these judges. If you try to address them as sir, don't be surprised how offended many of the judges would be because you're not calling them your lordship. Uh, it is a sad reality. You cannot ignore that. There may be some advocates who are willing to give up colonial practice, but they're not going to make much headway before pompous judges.
Right, right. Although I must say that there are both kinds of judges, exception to both the theories. So we have one question where the person says that, as stated in the judgment, perhaps he is referring to the recent Prashant Bhushan judgment. As stated in the judgment, if Prashant Bhushan fails to pay the fine of rupees 1, he would have to suffer 6 months of imprisonment. Did the apex court had made some flaw in the judgment, since failure of paying fine invites one-fourth of the punishment regarding the concerned crime, and maximum punitive measures for contempt of court is 6 months of imprisonment. Hence, if Prashant Bhushan had failed to pay the fine, he would have supposed to serve the sentence of 6/4, 6/4 month, that is 1/4 month of imprisonment. I couldn't make a sense out of this question, but if you would like to make some comment upon what he's saying, whether we can reframe this as something like whether the punishment was sufficient or was it just a token punishment of 1 rupee, just as to give a symbolic punishment. So we can take this question in this way.
No, actually, the questioner is saying the exact opposite, or meaning the exact opposite, because the thrust of the question, as I interpret it, is that the Supreme Court was being too harsh by suggesting that if Mr. Bhushan did not pay the 1 rupee, then he would be made to suffer 6 months of imprisonment, where in fact, under I don't know which law, it is probably the Criminal Procedure Code, failure to pay a fine invites a punishment of
Section 30.
one fourth the maximum duration of punishment of imprisonment. Probably, I must confess I don't know the details of these laws because it's now more than 30 years since I stopped practicing in India. But I'm assuming it's that. Look, there's no point in nitpicking in that way. Really, the long and short of what happened is that there are serious issues to be discussed and debated in relation to how the Prashant Bhushan case or cases were dealt with. I'm reluctant to talk about that, not because I'm afraid to talk about these things, but because there is, I think, an appeal pending. And it is only fair that we give the courts an opportunity to resolve that huge issue. And maybe if you're interested, after the final verdict comes out, because in India, an appeal is not the end of the matter, because then you have a couple of other processes. I can't remember exactly what they were, review and curative petition, this, that, and the other. There, it's endless. So I don't know, 10 years down the line, maybe there will be some degree of finality, but even that I'm not very hopeful about.
Yes, I think this is what he wants to bring out, that the independent constitutional power to punish. So I think this is how because I read the judgment, so court have discussed this in greater length, why this punishment.
Yeah.
And sir, and now when we are ending this discussion, there is another tweet by Mr. Prashant Bhushan alleging that the Chief Justice should not have used a helicopter by MP government on his recent visit. So Prashant Bhushan has tweeted another tweet about the Chief Justice now.
Mm.
So by the time we
Well, some more fun in terms of another petition. Who knows?
Yes, sir.
Thank you, sir, for coming. And this tweet reminds me, it takes me back around 30, 35 years, 40 years, when one of the prime ministers used an helicopter, and that led to creation of altogether different sort of constitutionalism in India for a considerable period. And let's see how things turn up, because even now, the things related to freedom of expression in the court, the contempt, and allegations against the judges, they are quite vague. We have not come to certain clear answers as to what would be the solution to these. Let's hope we arrive at these answers anytime soon. And we hope to have more discussions on these issues in the times to come. Thank you so much for joining us.
Thank you. It's been a pleasure. Thank you, Siddharth.
Thank you, sir. Thank you, sir. I think it was a lovely session, and I enjoyed listening to the stories which I've never came across before in any book or any discussion, sir. Thank you very much, sir.
Thank you. All the best.
Thank you, sir.